Hi, everyone. Thanks for joining us today. We're going to give people a few minutes to log on and we'll get started shortly. Hi, everyone. Thanks for joining us today. We're going to give people one more minute to log on and then we'll get started. Good afternoon, everyone. Thank you for joining today's webinar, ER and the Legal Perspective, Integrating AI in the Investigation Process. We're recording today's session and we'll share it with you following the webinar. If you have any questions, please use the Q&A function on your Zoom panel. Now, I'd like to hand it over to our moderator for today's session, HR Acuity CEO, Deb Muller.
Thanks, Lexi, and hi, everybody. It's great to see everybody calling in and chatting in from where they're coming from. We have a great big group today, and I'm not surprised because of the topic and our incredible presenter that's with us, but it's wonderful to scroll through and see names new, see names of people I know. I wish I could have a chat with all of you. Feel free to link in with me on LinkedIn. I'd love to have more connections to the community. All right, I'm going to start right in because it is an exciting topic. We're talking about integrating AI into our investigation processes. I know it's a hot topic. Before I start, couple seconds to talk about HR Acuity. For those of you that might be joining us for the first time, we are the leading solution in employee relations and investigations case management. And we like to say that we take you from all the way from issue all the way through allegations. So our platform covers anonymous reporting, tools for managers when they're documenting employee issues, proper ways to conduct investigations in the system using technology to really help you, some with AI, and we're going to talk about that more today, and then all the data and analytics to really help you be more proactive and preventative to creating safe and compliant workplaces. So if you want to learn more about our technology, we'd love to share it with you, take you on a curiosity tour, just let us know. And in addition to our technology, we like to say we're the leaders in employee relations. This is all we do. We eat, breathe, drink, sleep it. Many of you are familiar with our benchmark study that we do every year. This is my little prop. I'm going to hold up the actual study. You can download it. You can download 8 years of it because we've done it for 8 years on our website. And we right now are collecting data for our 9th annual study. So Lexi will put the links in. If you have 1,000 or more employees, we encourage you, please, to participate. It makes our data even stronger year over year. We have some great benchmarks in here. Last year, we had our study covered over 8.5 million employees. I don't know, my personal goal for this year is 10 million, so we need your participation. We also have our ERQ, which is our employee relations quotient. You can find that on our website to really see where you are on your journey in employee relations. It is the first ever maturity model for employee relations. And then, of course, we have our roundtable event, which we're going to be announcing very soon. It's going to be in the fall, and that's when we get together global employee relations leaders for really 2 days of collaboration, brainstorming, thought leadership. It's really a one-of-a-kind, incredible event. And finally, I'm assuming, but maybe I shouldn't, that all of you are part of Empower. If you do anything employee relations, you should do that today. It's free to join. It's an online community exclusively for employee relations professionals. Great live feed, job posting, sharing. It's free. So join. We have over I think about 6,500 members right now, and that is growing as well. So please join the community, continue to engage with us. I think this year more than ever, although I've said that before, we're going to need to lean on each other with all the changes that are coming out, and how do we really support our employees and our employer as employee relations professionals. Okay, next slide. For those of you who this is your first webinar, or if you're familiar with our webinar, you know that as a thank you for you coming to listen to the webinar, but specifically as a thank you to our experts that join us and share with our community, we like to make a donation in their honor. And today I'm really excited that we're making a donation to an organization that's really close to Lori's heart. And it's the Hospice of Central Ohio, and they really do some wonderful work. It's a not-for-profit hospices in Ohio to really help families and patients in their time of need. So we're thankful that we're able to make a donation on behalf of all of you and behalf of Lori. Upcoming events, and then we'll get to our event. But for those of you that are here today who are HRQD customers, we're sort of having an after webinar panel. So Lori's going to join us on February 5th at 1 o'clock again. So thank you again, Lori, to continue the conversation and do some expert Q&A on today's conversation. So that is an exclusive for our customers. So if you're part of that group, please join us for that. I think it's going to be great. And then for our entire Empower community on February 13th, our next webinar is on workplace investigations in 2025 and what you need to know. And Catherine Perez is going to be leading that. She's terrific. And again, 2025 just might be a little bit different than 2024. All right, so we ready to start? Okay, we're ready to start. So I'm really excited to get this launched off. As I already alluded to, we are joined, I see her on the screen, by Lori Deem. Lori Deem, as many of you might know, is a partner at Hughes, Sokol, Piers, Resnick, and DYM. She's been an employment lawyer with over 20 years of experience representing individuals in a wide range of employment matters. She specializes in assisting senior executives with job transitions, change and control situations, and drafting and negotiating employment and severance agreements. Lori has received numerous accolades for her work, including being named one of the top 50 women lawyers in Illinois in 2022. Now, that's what's written here. Now I'm going to tell you what I think about Lori. First of all, she's a plaintiff's attorney that you're going to love, which is maybe something you've never heard before. Lori has been part of our HRQD roundtable ecosystem for many, many years. She's almost been to as many roundtables as me, sharing her wisdom and her outlook and her sense of humor with all of us. And she has become, everybody's like, is Lori coming back? Is Lori coming back? So she's really such a part of our community. We love having her. She's a colleague, but she's also become a very dear friend, and I'm so excited for her to be here. So Lori, welcome, and excited once again to have you share with our community.
Thank you so much, Deb. Thank you, everyone. Like you said earlier, it was nice to see so many familiar names pop up, but so many new names as well in the participant window. So welcome, everybody, and thanks for joining us today. I promise you that my goal is not to throw a giant bucket of ice cold water out of Lake Michigan, where I am on the concept of using AI in workplace investigations. I'm just here to give you my thoughts and my perspective from sitting behind this desk every day and being a plaintiff's lawyer on where we need to, we need to be cognizant of the cautions and the potential pitfalls, but also do something about it and see if we can find a way to integrate the technology in a way that is safe and responsible, but also avoid some of the susceptibilities that we all know can creep in even with us as human beings, let alone with a bot. So I think what I'd like to start with before we get to how you can use AI at each turn of the investigation lifecycle is just, first the question, are you already using it?
And Lori, this data here is from our benchmark study from last year. We've been asking this question for a long time, actually, but last year finally got a little bit more deep into it, just given everything that was going on. The availability of AI really took a big turn last year. And so you can see here, not only 9% are really fully embracing AI and ER, and I'm not really that surprised about that.
I'm not either. I think this is probably consistent with how other parts of the employment or HR ecosphere are using it, and some of the trepidations that everyone has. And I think we are in this phase where we can develop guidelines and navigate the legal challenges and sort of figure this out as, the professionals, right? And the ones who hopefully are the gatekeepers of how do we use this responsibly. So
Yeah, it's not unusual. This sort of curve is not unusual for new technologies. And so the fact that there is more than half, and I bet that's grown since this came out in June,
probably
trying to
right.
figure it out. And that's part of what this discussion is all about today.
Absolutely. So, the other thing that I want to say, by the way, is that I certainly don't represent, let alone have I used or gravitated myself towards any particular technology. So I'm not going to be really talking that much about specific AI products because it's not my goal to disparage any particular vendor in this space. I'm just going to speak more globally about some of the pros and cons that I see. So starting off with just sort of a high level overview of the general concerns that come up when we talk about integrating this into our workplace investigation lifecycle. And the first is pretty obvious. It's data security and confidentiality. And I don't pretend to be a data or cyberspace expert, but many companies absolutely refuse to bring AI into their ecosphere for any usage, whether it be chat GPT to write performance evaluations or anything like that, because they are worried about the data security and potential for data breaches that come with inviting any new technology into their world, let alone one that the vendor still has an ongoing connection with the employer. So this is verboten in certain highly regulated industries, period. But those that have started to adopt it have acknowledged that you need to be very cognizant of the difference between a closed loop data set and an open loop data set. And I think by its own words, you understand the difference. But just so we're clear, a closed data set is your own data is what is educating the AI algorithm about how to learn what your patterns are, what your information is, and learn how to recognize it and suggest new things to you. Versus an open data set is taking your information and sending it out offsite to the vendor and allowing their data set to be educated by your data, but also then you're educated by all the other data, and suggestions come from there. There are obviously higher risks inherent in the open data set. And that's why most companies that are adopting some sort of AI into their HR or their ER platforms are opting towards a closed data set. That can be more expensive because it requires customization and working very closely with the vendor to create those data sets in order to educate the bot. But it is the preferred method if you have a heightened concern about security. But even in a closed loop, there are still other concerns like the ones highlighted here on the slide. And the biggest one is bias. And we'll get to that in a second. I'm just going to talk about the other two real fast, and then we'll talk about bias because I think it's the one that we as HR, ER, employment law professionals are the most concerned about. But the other concerns are generally how are stakeholders, whether we're talking senior level executives and your board of directors, but also stakeholders all throughout the organization, how are they reacting when they hear that you're considering or you're actually beta testing using AI in workplace investigations? What are their reactions going to be? How do they feel about should we be transparent about it or not? And what's the overall workplace reaction to this? And this can be managed, I think, with a very clear communications plan, and we'll talk about that later when we get to best practices. But usually people come to the concept of AI with their own preconceived notions, whether it's informed or not informed. And so that's one thing you're going to have to manage during the adoption phase if you decide to go this route, is how is everybody reacting to it and how much are you going to be transparent? And when I talk in a minute about bias, so far the legislatures that have wrestled with this have opted are leaned in towards the idea of transparency. They believe disclosure is very important. If you're going to use AI at the hiring phase, for example, or in the employee relations investigation phase, you need to tell the employee population that that's what's happening so that they can make an informed choice about whether they're going to participate. And so transparency seems to be something the legislatures are leaning into. And so I think, frankly, from my perspective, any organization that adopts this should lean into transparency. And I know that's music to Deb's ears, given how much transparency has been, an important discussion topic for HR Acuity over the years. The last one, and this is me just worrying about all of you because I represent individuals who get fired all the time, is that if we lean into this too much, the first is that we're potentially diluting the value that we have built, the institutional knowledge, the experience, the judgment calls that we've made over the years. We're diluting the value of those skills, but most importantly, we're diluting our perceived institutional value. And it could be a bit careful what you wish for, that the more reliance on the technology, the more headcounts go down, and you're engineering yourselves out of jobs and potentially engineering out of the profession. Now, I don't think the profession is going to disappear altogether, whether that be a need for in-house investigators or outside investigators. But I do believe this over time could be an existential threat to headcounts. And so I really do think we need to take it seriously and be cautious about when and where and how we're adopting this into our processes. So I think we'll turn to bias now, because that is the one that is top of mind for most people who do what we do. Next slide. Great, thank you. So I've broken this down, and there may be, at first glance, a redundancy here between anchoring and confirmation, but I'll explain the difference. Anchoring is a bias that comes up early in the process when you are really trying to lay out the plan. And the question is, if you lay it down a baseline of what the issues are and what the potential areas of contradiction or what the areas of inquiry are, do you get too wed to that, or does the AI algorithm get too wed to that initial baseline such that it is keeping the focus too narrow and not allowing for other possibilities of either witnesses or evidence to be considered? Versus confirmation bias is when you're later in the process and you're doing your conclusions or your assessments of the evidence and weighing the evidence. Is the AI tool going to gravitate towards a certain pattern, and that pattern is to confirm what certain baseline conclusions were? And so they sound similar, but they're not. It's about what stage of the process you have to worry about each of those biases clicking in. False confidence is just not, quite frankly, testing any of the information or suggestions or conclusions that the algorithm may send to you. But the big one is implicit bias. And research has shown that the certain AI algorithms that are used for recruiting tools, for example, have been shown to have a bias towards hiring white males as opposed to females or minority candidates. And why is that? Algorithms look for patterns, and they gravitate towards patterns. Anything that's anomalous gets kicked out. And so this is a situation where the AI likes repetition. The algorithms prefer and gravitate towards things that fit the pattern that it's determined through its algorithmic analysis. And the World Economic Forum has identified implicit bias in AI as a global concern. And as I referenced earlier, the legislation that is coming up right now that so far has touched on this subject, mostly in the hiring space, has determined, has already acknowledged that this tendency toward implicit bias is something that we should be looking out for and cautioning, and perhaps even prohibiting. And so Illinois and Maryland, for example, prohibit the use of AI in job interviews unless you go through certain disclosure and consent phases to obtain consent from the candidate. New York City has gone even further, has those disclosure and consent requirements, but also requires bias audits to be done every 2 years on any tools that are used in the hiring space. And so those laws are the first ones of their kind. There's no law that I was able to find in doing my research for this presentation that specifically touches or prohibits or curtails the use of AI in workplace investigations. But I do think these are instructive for us in terms of as we go forward and create our own guardrails and regulations. But one thing that is a sort of ripped from the headlines and breaking news that I wanted to bring your attention to is that the state of Texas has introduced a bill called the Texas Responsible AI Governance Act. It was introduced in the Texas legislature just a week and a half ago by a Republican representative, which I think is very interesting when you contrast this proposed bill with the most recent one of the executive orders on AI that was put forward and signed last week. It seems like the federal government, at least, is let's take off all the guardrails and let's move very quickly so that we keep our competitive edge on AI. But this proposed Texas law, which the acronym is TRAIGA, so I'm going to call it TRAIGA from now on to make it easy for us. TRAIGA is much more progressive in many ways than the statutes that I previously referenced, because it actually prohibits AI if the use of certain AI tools where discrimination is a susceptibility, and that employers have to use reasonable care to prevent algorithm discrimination. So it puts the onus on employers and on the AI creators to be the gatekeepers on whether or not discrimination is creeping into this process. And it does propose that there would be a task force that would do discrimination or bias audits to ensure that the technologies are not employing bias or fostering bias. It also defines what is considered a consequential decision, where AI is prohibited from being used unless there's full disclosure. And those consequential decisions include employment or employment opportunity decisions. So I really encourage you to take a look at the Texas statute. I'm not going to go much further and talk about it right now because we have so much else to cover. But it is, I think, in many ways, it's putting up stronger guardrails than any of the other laws that are currently on the books or that have been proposed, with the exception of a law in California that was rejected last year. So I think Rebecca's note in the chat is very well taken. This is moving incredibly rapidly, and I think we're going to see each state take its own hand and make its own decisions on whether this is going to be a state that wants to allow AI with no guardrails, or if the states are going to be putting up more guardrails, because the executive order that was signed last week suggests that there will be more discussion on the topic over the next 6 months. And so I don't think the federal government is in any position right now to adopt any specific regulations. And I don't say that as that's not a political comment. That's just I think they're still in an assessment phase, like many other legislatures are. But the Texas law models itself, by the way, on the European Union AI law, which is vertical and allows for each country to adopt its own specific restrictions. So I think that's where our country is right now, is that we're in a vertical model where the feds are not taking a very strong stance on this yet. They're still in the assessment phase, so states are filling in with their own ideas. Deb?
Yeah, I just wanted to point out, I love your list here, but you flew over the false confidence one, and I know you have a lot to say to it. I have a lot to say on that one, because I do think as employee relations professionals, we bring something special to the table that AI has yet to prove, and that sort of, you use the word curiosity, it's judgment, it's understanding the context of things. And that's what worries me. You know, people use AI, they become so reliant on it. I always tell people, well, how many of you have actually read those click-throughs that, you get before that you all those things that you agree to? And I fear that I see these systems put things in that sort of generate, and they say, well, that's okay. We'll have you check something saying that you've reviewed it as a human. And I'm like, yeah, really? Really? Are you going to do that every time? And so I think that's when we really need to pay attention to.
I would agree, and prescient as always is Deb Muller. I was going to hit on it really hard later on.
Okay, good. Wait, I'm going to do, because you're going to do better than me. So I'll let you
Because
keep going.
it's one of those things where I do think, if you're using the algorithm to come up with original thoughts, right? Conclusions or synthesize, which we'll get to in a few minutes. I think that's where the danger lies versus using the tool as a verifier of ideas you've already had yourself, right?
Yeah.
To make sure you didn't miss anything. And that's one of the key takeaways I would like everyone to have today is, I don't think these should be verboten, but at the same time, don't let it supplant or step in for what you bring to the table. I think using it to double check yourself or using it to verify that you haven't missed anything because we're so busy and our plates are so full, then that is where I think it can come in handy and help us.
Yeah,
So
great. Well, I'm going to let you go on then, because I know
you're
you're
fine.
going to.
No, but it's absolutely true. And I think that is a bias that is inherent at every phase of the life cycle. But particularly when you get to where you're applying the judgment and the institutional knowledge and all of that to what you've collected.
Awesome.
Okay, so next slide. So we're going to run through each stage of the ER life cycle. I'm sure I've missed something along the way, but I tried to, sort of stop at each of the main inflection points, the most material inflection points, and talk about both the upsides and the cautions. So the first stage is complaint intake, right? It doesn't happen unless we start with a complaint, and where that comes from is obviously up to each of your individual mechanisms, whether it is, an anonymous portal or whether it was an HR complaint that was made to, person to person, a written complaint, whatever. So the question is, what can AI do for you in this space? And it can certainly do transcription and do intake notes of hotline accounts, categorize the complaints and the nature of the allegations, identify potential policy violations. There's a number of things that the AI can do for you in this space. I think where you have to be concerned is with what I said earlier, the anchoring bias, where again, if you're using the bot and you're adopting its conclusions or its summary or all of it blindly without looking at the raw data, or at least getting your eyes over the raw source material, then it is possible that the bot has started you on too narrow of a path, or has mischaracterized what the complaint is really all about. And that last one, should send shivers up all of our spines, right? Is that the bot got it wrong and we didn't second guess the bot. And so we go down the wrong path from the beginning and get things wrong or miss things that were material. And so I think using the AI technology at this stage is relatively benign, so long as you're not using it blindly, and you are putting your eyes over everything. Okay, so the next phase in investigation planning and prep. There are some tools in this space. The one that really I think most people might be most familiar with is All Voices. This is, using the algorithms to analyze complaints, draft an investigation plan from those basic inputs regarding the nature of the issues, coming up with the witness list, the order, and what other material needs to be collected, whether evidence needs to be collected, prioritizing the investigation steps based on identified risks and sense of urgency. Those are more sophisticated applications, but the tools do allow for that. Anchoring bias, again, there's a susceptibility for that here, obviously. And I think I will just say point blank that I think that this would be considered, this would be considered an inflection point in the investigation life cycle where decision making, there's consequential decision making, to use the words from Treja, is happening to determine what the course of the investigation is going to be and what the potential outcome is going to be. And so I think this is really a moment in time where you should pause and very carefully consider whether you want the algorithm or the bot to do your work for you. I say that because, anchoring bias comes in, but also, do you want to have to defend to someone like me in a deposition down the road that you allowed an algorithm to create the investigation plan, decide what witnesses would be spoken to, decide what documents would be obtained? Do you want to have to defend that should everything go awry and there be litigation? And, should this formative step be left to an algorithm that's either learned from a closed data set or an open data set, but hasn't learned from years of experience and knowledge of the institution and applied judgment, like all of you bring to the table? And so I'm not a fan, to put it bluntly. I'm not a fan of using any AI in this part of the process. I think it's just too important. So I think that there are places where you could use it to verify your work to make sure you're not missing anything. But if you are using it for original drafting, and keep in mind, you are making evidence with every choice that you make at every stage of the investigation process, you will have to explain why you let the algorithm create your investigation plan from scratch, rather than you created it and used a bot to verify it. I see that some people are agreeing with me in the chat, and so I appreciate that. Thank you. So moving on, the next phase is witness interviews and other evidence gathering. And so some of the products in this space that I think people are most familiar with are Casetext. And particularly when we talk about transcription, Fireflies.ai and Rev are some of the technologies in this space. And so what I would say is that I have a mixed opinion about what the tools can do for you and whether tools can be helpful in this space. As you can see from the uses and upside side part of the slide, I think there's the whole gamut from sample questions to transcribing witness interviews in real time and preparing a summary for you, and to using the tool to analyze and highlight contradictions in witness statements, either in real time or after the fact. And we'll get to after the fact in a minute. But then there's tools that will offer you questions in the midst of a witness interview. So it'll be sort of attached and working alongside of you, suggesting questions to you as you're doing the interview in real time, versus there's the tools that will actually, again, assess the witness based on biometric feedback and cadence and speech patterns and visual cues. Does the person turn red? Like there's those tools that will assess credibility in real time based on visual, verbal feedback. I have strong feelings about all of them. What I would say is that the ones that offer you sample questions before you start your interviews and things, I think those are great. Again, so long as it's not an original drafter and you're using it as a double check on your own work. But the ones that are in real time offering you questions, that could be disruptive, first of all, and distracting, but also depending on how much you have disclosed this to the witness who's being interviewed, this could make them very nervous, and it could alter the way that the witness shows up in the interview if they know that not only are you using just a transcription tool to help you take notes, but you're actually using a tool that is responding or reacting to the way that they answer questions and offering you new suggestions that you didn't come up with yourself, or you want to use that instead of your own thoughts of follow-up questions. So I have really strong feelings that the more you are leaning into these tools to do the credibility assessments, I think this is where implicit bias, confirmation bias, all of the bad things that we worry about can creep in. Because as we talked about earlier, the facial recognition and biometric tools are fraught with a potential for bias. Again, because they're looking for patterns, they're looking for the norm. And so if the witness shows up and doesn't act like what the algorithm thinks it should act like or sound like, then it's going to flag it. I don't think that's fair because there are a lot of people who have different reasons for not acting normal or not acting how the bot should think it should act in a witness interview, whether that be nervousness, whether that be neurodivergence, whether that be speech impediments, whether that be hearing impairments, whether that be just plain old nervousness and anxiety. So I think that this is really fraught. And once again, Trasia identifies the collection of biometric feedback for the purpose of making employment decisions to be a consequential decision in the employment world that should be either prohibited or closely monitored. And so I'm not just the only opinion on this. I mean, I never thought I would say I agree with the Texas legislature on this one, but I do. And so I think that this is something that we have to be really careful about. Generally speaking, I think that transcription is fine. But again, if you're relying on it blindly without taking a look at it and making sure that the transcription is accurate, you are taking a huge risk. And I will give you a quick cautionary tale. I received a call from a potential client who had participated in an investigation. They were not the subject of it. They were not the complainant, but they participated in it, and they were asked to, then they were presented with a written statement of summarizing what their testimony was in the interview, and it was completely wrong. And they wanted to correct all of the inaccuracies, and they were told, no, you can't do that. This was collected with technology, and we perceive it to be accurate. And they felt that somehow their rights were being violated by not being allowed to correct their own statement. Now, I know none of you would disallow someone from correcting their statement, but it just goes to show that, this was a situation where it was fraught with inaccuracies and the technology had done the transcription. And so I just say it as a cautionary tale of these things do happen. And I think you may be adding more work to your plate if you are having to explain or deal with things that are unintended consequences of the use of some of these technologies. So instead of making your lives easier, I think it could make your lives harder. I see in the chat someone asked, how could it be so wrong? Just to be clear, this potential client was had a very heavy accent, and the transcription tool apparently couldn't understand their accent. So there you go. So turning to the next slide, because I know I'm being conscious of our time here, and I want to leave time for questions at the end. So the next phase is your case summarization, synthesis, and report drafting. And I know that's a lot. That's actually 3 stages in one, but I wanted to, for the sake of brevity, combine them all together. I think the tool that we're all most familiar with in this space is Case IQ. And again, I'm not bashing the vendor, not bashing the tool at all. So I think that's the one that most people are familiar with. And I don't know if, anyone has positive experiences with Case IQ. But if you have, that's terrific. I would say I am aware of some negative experiences with Case IQ as well. But again, it's just the idea that the tool can help you by summarizing witness interviews, other supporting documentation. It can actually synthesize the evidence using pre-configured templates that you all can set up yourselves. So I see where that's an advantage. If you have a way of collecting and sifting and sorting evidence based on standards that you and your team have developed and templates that you all like to use, I see where this is a huge advantage. But where the algorithm goes a little further is that it basically takes and it does all that sifting and sorting and leads to a preliminary set of conclusions. And I'm concerned about that. Where it can go even further is it prepares, the first draft of the investigation reports, or certain other tools can take your draft and offer revisions or draft certain language, spot issues with your tone, where places where you might not be as neutral as you should probably be. So there's lots of different functionality that can happen under some of these tools, depending on whether you're asking it to do the initial draft or whether you're feeding it a draft and asking it to do some double checking or some verification, either for synthesis or for tone or grammatical errors or inconsistencies. And so, as I said before, you just take a little sip of water. Using the tool to verify original thoughts that you yourself have had, I see no issue with. So long as you are comfortable with the idea that if you somehow have reached certain conclusions, but you change those conclusions based on what the algorithm tells you, again, you're making evidence and you will have to justify that change of conclusions or those alterations to your investigation report. And so but I think that's much more defensible than the report was drafted originally by the algorithm, and then you went in and tailored it or retooled it based on either things that you saw that were inaccurate or things that were not as amplified or consistent with the conclusions that you reached from your own judgment. I think allowing the bot to do the original work is really dangerous in terms of being able to defend the validity of the overall investigation report. And I think, again, it depends on how much you're letting it summarize, what you're letting it summarize from, and then what are you doing with those summaries, and how much of your own judgment, your own knowledge, your own impressions, your own fact finding from your notes and because you've been doing the investigation all along, how much of that are you applying as original thought processes versus how much are you relying on the algorithm? And I think particularly until we all get to some industry standards on this, you're running the risk that if the case goes sideways and you end up in litigation, you're going to be very vulnerable to someone in my shoes sitting across the table from you, asking you questions about why you seeded certain judgments, why you reached certain conclusions, or was it the bot that reached the conclusions? The bot can't sit there and answer my questions. Only you can. And so if you have seeded your judgment and the most sort of empirical parts of your job, in my view, to the algorithm, you're going to have some explaining to do for that. And so I think this is, and speaking, more existentially about headcount and your jobs being safe and the profession being safe, I think the question becomes, is this the kind of non-administrative work that you should still be doing versus ceding to the technology? Because I think dividing your plate into what is administrative work that hopefully technology can assist and aid and speed up and make more efficient for you versus the non-administrative work that should be entirely your province is what needs to happen here. And I assume all of you that are working and working this through already and adopting these technologies are thinking about it. And so I see that someone put in the chat that, the new Chinese technology provides a chain of reasoning. I still don't think that's going to hold up in litigation because its chain of reasoning came from data sets that are either internal or external. It did not come from a data set that is based on institutional knowledge of this particular organization and judgment calls that only humans are qualified to make. And my view is, if you say, oh, well, this data set is ours, and so it's working off of our own reasoning, then I hope you are prepared to call someone like me when you get terminated, because you're basically going to be engineering yourselves out of jobs. And I don't mean to sound so alarmist, but I believe that's actually true, because I had a friend call me last week and she was downsized because her company told her that AI could do her job instead of her, which is absolutely not correct, in her opinion and mine. But, you know, it happened. And so I do think this is a vulnerability that we all have to look out for. And it's not just about protecting our own jobs, it's about protecting the validity of the discipline that we have spent a lifetime developing, but also helping employees in a way that is still very humane, and is still helping employers make smart decisions, to keep the workforce, happy and healthy. And we have a job to do. And I think the more that we cede it to the technology, the worse off we're going to be. And that is, that's my humble opinion. And you can agree or disagree with me, and I'm perfectly comfortable with that. So, moving to the last slide, without all the doom and gloom, I do have some recommended best practices for all of you to adopt, and most of these you would already think of yourselves. I just wanted to capture them all in one place for you. Developing a task force, and considering the questions that you should, identifying specific case types that you think this is something that you want to beta test, and scenarios where this will work for you. I think there's a huge difference between certain types of investigations where this can be extremely helpful versus the more complex ones that we all sort of have. It's the octopus investigation that has 8 tentacles, and it's going to lead to this outcome or have these ripple effects in this part of the organization. Those probably are not well suited to any insertion of AI, unless we're just talking about basic transcription and things like this. But then you create a beta test set and go through an experimental phase and test and talk about how it's working for you before you adopt it on a large scale. You really have to, in number 4, you have to really put your vendor through their paces about what they're doing with your data. If they're creating a closed data set for your organization, that's great, but they still have the data, within their tool. And so what steps do they take to protect it from data breaches and cybercrime and all of those important things? So put them through as many of the questions as you yourselves go through to ensure that it's insulated from cybersecurity, or pardon me, from incursions from cybercrime. Consider a closed data set is the only way to go. And then the last one, developing the communication plan, and deciding how much transparency you want to have, both at an internal level versus an external level. And what is the messaging going to be for why you're adopting this technology, and what's being clear about what the pros and cons are. But also, I think allowing people to opt out. For example, if you're adopting a tool that is going to be a companion while you're doing a witness interview, not having any negative consequences for any witness that doesn't want to consent to the tool is really important, so that you're not accused of any sort of retaliation in the way you're conducting your investigations.
Lori, this has been great. I don't know if you've been reading all the comments on the side in the chat.
I can't.
A lot of, we'll make sure you get a, we'll make sure you get a copy of the sort of what people are saying, because people are just sharing some of their own experiences with AI or questioning it. Really great discussion. This is so thoughtful. We do have about 10 minutes for questions if there is some. We had some slides to talk about what HRQD is doing for AI. I don't want to go through those. I mean, we'll show Oliver here. I will just tell you that we reach out to experts like Lori to talk about it. We really are taking a very thoughtful and responsible approach. We do have Oliver, some of you familiar with, he's our AI companion, or I'm sorry, ER companion, to serve up employee relations thought leadership, to help with our analytics, looking at that closed data set, different ways that we're working workflows. And we're trying a lot of things. And by the way, we've tried a lot of things and then stopped them and said, no, we don't like those. I remember putting in some data about an investigation into one of our trials, and it didn't pick up a very important nuanced detail in that investigation about what someone had eaten at dinner, which could have been verified. And they just were like, they went to dinner. Like it was, those are the details we know in investigations that are so critical to help determining credibility. So I'm going to open up to see if there's some questions here that anybody would like to ask. Rebecca, do you have any questions? Well, you can join us too if you want. Hi.
Hi.
Everybody knows Rebecca. She's our Chief People Officer
Hi.
here at Acuity.
Yeah, we had one that I think was back a couple of minutes ago. Daniel was asking, what about any prompts or data sets that you provide before the input that you're asking AI to analyze? Like, would that change it? Like, if you're really guiding it? I think it's still risky, but
So let me make sure I understand the question. So you've got some basic information that you're feeding into the algorithm, and you're asking it to prompt you for questions or for
analyze that is what Daniel is saying. But Daniel, feel free to type in any clarifying points there. I think it's all to be taken with a grain of salt. If I like,
Yeah, and again, I see no issue with this being a supplement or sort of a verifier versus an originator. Those are my words. It's not anything in the law. It's not, but I was trying to, think how what am I comfortable with, right? Where. And I think there's a big difference between if this is the originator of some of these crucial stages of the process versus if it's a verifier, or if it is some your last your double check before you move on to the next phase, right? So if, for example, you're in the planning phase and you've already got your investigation plan mapped out, and you just want to run it through the tool to say, am I missing anything? Or if you're coming up with your witness questions, and you want to run it through the tool to make sure you haven't missed anything based on some basic, prompts that you've given it on the issues at play in the investigation, I see no problem with that, because, it is basically supplementing what you've already brought to the table. And you say, I just wanted to make sure, and that goes to the thoroughness of an investigation, right? I mean, we have some words we live by: prompt, effective, and thorough, right? And under thorough, if you're using the tool to make sure you didn't miss anything, I think that is perfectly defensible.
yeah.
But it's the originator of all the thoughts.
That's the distinction. Yeah.
That's where you run the risk that you are
Right.
second guessed by someone like me, or by your boss or your CEO or whoever doesn't think this is a good idea.
Yeah.
Wait a minute. Why do we have you if you asked the bot to come up with the questions and you used those in the interview without ever adding anything else to the mix?
Right. Okay. That makes sense.
We try to use the approach. We still take the approach of what's a good investigation and how can we use technology to really still do a great investigation, sometimes faster, sometimes more thorough, or be able to do things a different time. And then we think about, gee, just like any other technology, is AI one of the technologies that can help us achieve that? As opposed to, oh, great, here's this AI. We now have to push it into our system because everybody's talking about it. That's where you're going to get into trouble.
Yeah.
I see systems where they're taking an input about like complaints. Someone will write in everything that'll happen, and then they'll say, oh, that's harassment. And as an employer, I never want a system putting words, legal terminology such as that into the hands of my employees. What happened? We'll take care of it. Let's not categorize it as legal, something that could be unlawful.
Well, exactly. And it goes to, which I think was one of the big, one of the big revelations that, or one of the things I just want to drive home, is that at every stage of the continuum, you're making evidence. You're making evidence. You're not just collecting and sorting and analyzing evidence. You're making evidence that can either be used to the company's advantage or to its disadvantage, depending on, whether it gets in front of someone like me. And so, if the algorithm has assigned legal terminology to something that is really, baseline, bullying behavior, and bullying isn't illegal yet in most places, but it's called it harassment or it's called it hostile work environment. Do you want that? Do you want a record made of that?
Right.
And that you carried it
I don't.
that you carried it forward without correcting the terminology too, right?
Yeah.
Someone did ask,
I'd be
any
happy for it,
specific-
clearly, but
Yes, that's right. Let's remember Lori's role here.
yeah.
This is the only time you want to be seeing her, by the way, or at the round table.
Yeah, exactly. Then it's okay.
Or sending me referrals. I'm okay with that too.
That's true.
I think a lot of people in our community have experience with transcription software that they're using internally. And someone was asking, are there any specific risks associated with that? I think you've touched on that.
Yeah, I would just say
accuracy.
if you're not checking its accuracy,
Right. Okay.
that goes to that PC, that potential client that called me, is that it was pretty clear that no one checked it for accuracy, and they just adopted what the transcription tool had done. And to be clear, I mean, I found that person not to be so heavily accented that they were that I couldn't understand them. But again, the algorithms are used to a certain, they're used to patterns, they're used to the norm, they're not used to anomalies. And so, this may be a place too, where if you know your employee population and you know that, this particular witness either has a speech impediment or has an accent or whatever, you may be skeptical about using the transcription tool because it might spit out a bunch of anomalies and it might spit out a bunch of junk, quite frankly, that's only going to make your life harder. I saw that someone asked about consent and everything, and that is a big concept of all the legislatures that have dealt with this so far, is that the prohibitions are not absolute. But they are saying disclosure and consent is really important. And so I just would want you to establish a set of protocols that you disclose, and then if someone does not consent to the tool being used during their interview or whatever, that they are treated just the same as every other witness. That is not a notation towards their credibility, right? And that is not something that is used to in any way distinguish the value of their testimony, simply because they opted out. Because otherwise, then you're leaving breadcrumbs of potential retaliation or breadcrumbs of you didn't find them credible, and so it could undercut the validity of the entire investigation.
I definitely want you to read the comments when you get a chance later, Lori, because as usual, our community is very wise. So I encourage everyone to keep the conversation going and empower. Everybody join Empower and keep the chat alive. I think we all have a lot to learn in real time together as this is changing so fast.
Yeah.
I know I spoke a mile a minute too. I'm sorry I went so fast, but I had a lot.
It was great. And to our HRQD clients that are on the phone, please join us on February 5th. So you'll have some special time with Lori. Bring all those questions, think about it. We can have a real good discussion about this. To everybody else, keep the conversation as Rebecca said in Empower. If you want to learn more about HRQD, we'd love to share more about it. But this is, as always, thought-provoking and just so on the money as far as what's happening today and what we're all thinking about. So just a great conversation. And we're going to continue it because it's going to evolve, right? Just because this is where it is, it doesn't mean it's not going to change.
That's right.
Doesn't mean this is all we do, but you're getting a lot of love, Lori, here. So I'm not surprised.
Thank you, everyone. I really appreciate your attention and your participation. And I wish I could answer all the questions.
I know there was one about multiple languages. I mean, there's so much. We can't get
well, if we can pick some out, maybe get a response, put it in Empower. So we'll see how we can get to all of them. But thanks everybody for joining us. As always, come back for more to get on Empower to learn what's next. Thank you so much again, Lori. Thank you, Rebecca, for monitoring the chat and the Q&A.
My queen wave. There you go.
That's right. And we'll see everybody soon. All right. Have a good afternoon.
Bye. Thank you.